Thank you. First of all, thank you very much. Thank you for the invitation, and thank you on behalf of the AI office for inviting us to join this session in this important meeting here. I'm connected directly from the Brussels, the heart of Brussels, and thank you for the introduction. I should start the presentation now, and of course I'm available for any questions or remarks in the end, or in between if you want to intervene. Today I'm here to discuss the AI Act, to give you a few high-level elements of what is this regulation around the artificial intelligence technology in Europe. And next slide, I will start by. So we'll start with the main elements of the AI Act. AI Act is a regulation in Europe, is in force. I mean, it has been public since 2024. It's AI Act is the 1689 regulation of 2024. So there are some pillars along the way of the AI Act. The first pillar is that it is a product safety regulation. So its goal is to protect the health, the safety, and the fundamental rights of people, and it is oriented around a product and how this product should function, should operate, should not malfunction. So keep in mind that we see AI as a product. The second pillar is that the AI Act is horizontal in scope. That means that it's covering all sectors with an integrated governance system. That means that it's not AI in health, it's not AI in education, it's not AI in infrastructure, it's not AI in anything. It's generally AI anywhere, incorporated in systems or outside of systems, standing alone. The third pillar is the proportionality that is a principle that is all around the AI Act. That means that this risk-based approach that it has to be interpreted with proportionality. So we have to see what kind of risks its product, its AI product brings, and then try to mitigate it. The fourth pillar is that the idea of the AI Act is that there has to be trust along the value chain. That means the product manufacturer, the deployer, the provider, the importer, they have to trust each other in this chain of the AI lifecycle. Each of them have their own obligations and their own restrictions to follow. And of course, the last pillar, but not least, because in Europe we need, and we are trying, and we are struggling, and we are there to innovate more and more. That means that the AI Act is oriented to foster responsible innovation. That means that we innovate through regulation. So it's a regulation that allows innovation with specific provisions, not generally it allows. It has specific provisions to help innovation, like sandboxes and better conditions for SMEs, etc. And I will move to the next slide, please. An important part that I wanted to really highlight here, it's the definition of the artificial intelligence systems. I know that most of you in that room today, you really know what is the AI and you have used AI in your daily life. What is important here is that this is a global definition. This is a definition that has been agreed internationally, and that means that it is important to have in mind what is an AI system so that we know what is not an AI system according to the regulation. AI system means a machine-based system. So it is a machine-based system. It's not something biological, not something alive, that is designed to operate with varying level of autonomy. So autonomy here is a very, very key element, and that it may exhibit adaptiveness. So I have there the elements of machine-based system, autonomy, adaptiveness, and based on explicit or implicit objectives. So it has some goals, some targets that the AI has to work on that, infers outputs such as predictions, content recommendation, decisions, which in the end can influence physical or virtual environments. That means that a robot comes to us and brings us a glass of water, just a very simple example, or an image is created or a speech is created online. That means the AI has to be able to affect our environment, an AI system, to be called system. And with that, we can move to the next part. So this is the heart of the AI Act. When we are talking about the AI Act, we cannot omit to discuss this pyramid that has been created with risks. In the basis of the pyramid, there is the green color. That means that there are no rules for AI with minimal risk. That kind of applications is, according to the research, the biggest part. So it's AI that is around us and that is not really affecting our day-to-day life, like a spam filter in our email, which is not really a risk for our safety, for our health, and for our rights. The second layer is the disclosure for AI transparency risk. We call it the transparency layer. That means that when an AI system is falling into this layer, we need to know that it is AI. This, as you all understand, of course, it's going to the deepfakes. It's going to fight the deepfakes battle. It's related to the chatbots, and generally, when people use chatbots, deepfakes, or content generated through this, they need to know that this is AI generated, AI content, that this is an AI communication. And this is for transparency risks because people have to be able to not confuse AI with people, with human interaction. The other layer is the requirements for high-risk AI systems. That is the high-risk layer. You see that it's getting red and orange, and in the end it's red. It's because of the obligations that start to apply. When an AI system is in place, is operational in employment or in healthcare or in justice, medical devices, then the AI is called as high-risk AI. That means that it is allowed, you can use it, but in Europe, but you have to be really careful about it. You have to have a whole file of documents and documentation and quality assurance and risk management in place to make sure that this high-risk AI system does not affect and does not violate any rights. You have to make sure about that before putting it in place. And of course, developers, deployers, providers, they have different layers of obligations to build this high-risk AI system. The final, and I would say most, for now, it is enforced because it is the one part of the AI Act that is already in place since last August 2nd. It is the prohibited practices AI. These are the systems that are not allowed in the EU. These are the systems that are in these days that we are passing over. These are to be out of Europe. If they are in Europe, to be out, and they are not allowed to enter. This is an example is manipulation of vulnerable people. It is the social scoring of people. It is the biometrics identification in real time in open spaces, so no mass surveillance allowed. There are specific, it's 5 categories, Article 5 of the AI Act, of prohibited practices that are not allowed anywhere in Europe. Of course, there are some exemptions there. An exception can be terrorism or an incident of kidnapping a child. So serious incidents might justify some exemptions from the obligation of no biometrics, of no remote biometric identification for real time in open spaces. What do we know about these rules? These are the main rules. If you open the AI Act, you can see that these rules are structured in place, one next to the other in chapters. They enable trustworthy development. They address major risks. So we are trying to address the major risks and not every risk. The risks that affect healthcare, safety, this is complementary to other EU laws, so that's also important. The AI Act does not abolish the GDPR. It says that it works without prejudice to GDPR. That means that personal data are protected based on the GDPR, but they're smoothly incorporated in the AI Act assessments. It is future-proof and adaptable. That means that it leaves lots of space for new acts, for revisions, for implementing acts that will change because AI is evolving. So an AI regulation has to be able to evolve. And next slide, please. Thank you. The AI Act timeline, that's another important fact. It started August 1st, 2024, so that means that the regulation entered in force. The general provision started to apply 2nd February 2025. That means the definitions are there, the AI literacy obligation, the prohibitions. 2nd of August 2025, last August, the rules for general purpose applied. This August, that is coming now, the rules for high-risk AI system are going to apply. I will tell you about it because there is a small difference here. I will tell you in a couple of slides about the digital omnibus obligations. And the rules for high-risk AI systems embedded in regulated products, it will apply a bit later, as you can see. Why this distinction? Because high-risk AI systems that are standing alone, they can change, they can adapt, they are new, they can change but when they are embedded in a product, let's say in a medical device, we cannot force them to change now. We need to give them time to make sure that this product is safe under the new regulation. And now the AI Act, please, the next slide. Now we'd like to present an interesting fact, I believe, for you, the extraterritoriality scope of the AI Act. That means that the AI Act can apply outside of Europe. So when providers outside of Europe are placing AI systems on the EU market, even if they are established outside the EU, or when providers and deployers are located in a third country, but the output of the AI system is used in the Union, or when the importers and distributors are placing systems on the EU market, these are the factors that lead to the AI Act applying to these manufacturers, to these providers, to the deployers, importers, even when they are outside of the EU. Next slide, please. And since we're talking about the AI Act, we cannot not mention the digital omnibus on AI. This is the amendment, amendment to help to simplify the AI Act. Please, next slide. And its goal is a simpler and faster Europe. That means that in October 2025, the Council called for further ambitious simplification packages, including on digital. That meant that the AI Act had to change a bit, not the basic structure. So the whole idea was the digital omnibus is the 7 of packages, and it aimed to alleviate 5 billion in administrative cost savings for businesses by 2029. And can we please move to the next slide? Okay, so the simplification of the AI Act is to address the implementation challenges, help companies navigate better, reduce costs, in addition to existing support measures. Next slide, please. I'm trying to make it a bit quicker because I'm not sure we have time for everything. What are the challenges? So the challenges that we faced was first and foremost standards. There are no standards yet created based on the AI Act, and that could cause legal uncertainty. So that is, again, with the delay of national authorities to be established, that could create problems for the member states and for the companies to implement the AI Act, the high-risk cases. So the alignment of timeline, that means that whenever the standards are out, then the high-risk obligations will start to apply. These are now tied together based on digital omnibus. Next slide, please. Other challenges were the compliance costs, the AI literacy obligations, registration burden. So we removed the registration for AI systems that are not high risk. Only high risk systems will need to register in a database. So we left some parts for voluntary guidance and tried to help the companies there to alleviate some costs. Next slide, please. Thank you. In general, there were measures to facilitate compliance, like allowing providers and deployers of all AI systems and models to process special categories of personal data. So in the digital omnibus, it wasn't just the AI Act targeted, some parts of the GDPR were also targeted, some parts of the cybersecurity regulations were also targeted. We tried also to foster a better system for the cross-border use of regulatory sandboxes. As you probably have heard, in Europe, we are creating sandboxes, one in each member state, but now we have joint sandboxes together. Member states are getting together and having sandboxes, and EU-level AI regulatory sandboxes. And of course, the last important measure that is taken now with the digital omnibus is the use of real-world testing for high-risk AI systems. Next slide, please. Thank you. And with that, we can move to the first, and as we said, the most strict category of the AI Act, the prohibited AI practices. And can you please move to the next slide? Thank you. So there are prohibited AI practices, as we said. We give you some examples, but you can find more examples and specific categories and what is specifically forbidden in the guidelines, because there have been guidelines issued last year, very thorough with examples so that people know how to navigate and what is forbidden and what is not forbidden, because there can be misunderstandings. So the first category is the AI-enabled harmful, subliminal, manipulative, or deceptive techniques. So you cannot use an AI companion to use emotional cues to influence users' feelings, so make them emotionally dependent from an AI system, or undermining free choices. Another example is the harmful AI, AI exploitation of vulnerabilities due to age, disability, or socioeconomic situation. In age, you can put kids, or you can put the elder people who cannot really distinguish between AI or real human interaction. So it's chatbots that makes use of vulnerabilities of migrants, let's say, or people generally who are in a specific socioeconomic situation, and trying to manipulate them into specific views, extremist views, or other harmful behavior. These are prohibited practices. Next slide, please. Thank you. Another important prohibited practice in Europe is the social scoring, the AI-enabled social scoring by public and private actors. So there shouldn't be data from unrelated context or disproportionate detrimental consequences, to have detrimental consequences. That means that a welfare agency, social welfare agency, let's say that you have an agency, they use AI to calculate the risk, score for likelihood of fraud. This is also a court case in Europe. A European country tried to use social scoring in their welfare systems, and they found out some fraud detection patterns, but they were only to predict fraud, and they were mistaken to predict fraud. So that created an issue there with these people who were predicted to commit fraud, although they hadn't committed yet. So this is a prohibited practice because you cannot use even unrelated data. Let's say what kind of car someone drives or what kind of friends they have, to create a profile, and based on that put a social score on persons. The other prohibited practice is the individual crime risk assessment or prediction of based on profiling. That means that you cannot predict that a person or cannot prosecute a person solely because of the outcome of an AI system. You have to have evidence. But here, attention that it is allowed AI to assist human assessment. It is allowed for our police to help themselves with AI systems, but based on verifiable facts and to not prosecute solely based on the AI. Next slide, please. Thank you. Prohibited practices. We continue with the last ones, the biometric categorization systems, assigning individuals to certain sensitive protected categories such as political opinions or sexual orientation. That means that we are not allowed to use biometric systems to give some specific orientation, some details on the persons based on the characteristics. And as I mentioned before, as a first example, it's not allowed to use real-time remote biometric identification. We call it RBI, real-time RBI, for law enforcement purposes in public accessible places. So although there are cameras around in many places, open places, they cannot be used for facial recognition and for recognizing identities of people, with some specific exceptions, as I mentioned before, with terrorism and other categories that are mentioned in the law. And with that, we move to the next slide and the high-risk AI systems. So we're getting lower in the pyramid that we mentioned before. And here we have the next slide, please. We have the explanation of what is an AI high-risk system. So it is a system that is embedded into a regulated product, or it is self-regulated product. So we're going based on regulations. If the product is based so let's say it's a machinery, we have the machinery regulation, and the AI system is intended as a safety component, or the product in question is subject to a third-party conformity assessments, then we have the two different conditions that this product is regulated in the AI Act. So if a product, let's say it's a medical device, in Europe we have a medical device regulation, that means that it is in Annex 1, but they have to have two conditions. The AI system has to be intended as a safety component, so AI has to work in the medical device to stop it from working or start it from working, or I don't know, if the heart goes really fast, then you understand that AI can stop the product or start it again. This is a safety component in not too many words. And this product as a medical device is undergoing third-party conformity assessment. That means the notified bodies. That means that this product is in high-risk category. And there is another line. So there are two categories of high-risk AI systems. There is another line. It's the standalone AI systems that are intended to be used in high-risk areas. So use cases and areas. One is going based on the product and the other is going based on the areas. So if an AI is used in the employment sector to hire or to fire someone, that is high risk. You can see the other example there. Law enforcement, migration, administration of justice, and other critical, sectors for Europe and for the world. There are, of course, there is a filter, we call it, an exemption from the high risk. Not every AI in employment is high risk. If an AI is performing a narrow procedural task, so just to, allocate the files in specific places, or improves the result of a previously completed human activity. Let's say that a person decided 5 persons that they want to hire, the employer decided 5 persons they want to hire, and you use AI to, ask who has graduated in a specific law school or who has graduated in another school. That can be used if it detects decision-making patterns or deviations and does not replace or influence human decision. That means that just identifying some patterns doesn't make it high risk. And of course, a preparatory task. If a justice system is using AI to allocate the files to the judges, then that is a preparatory task. It's not administering justice, so it can be used without being high risk, without the obligations. Can we go to the next slide, please? Thank you. Of course, there is another point, high risk in law enforcement. It's a quite important point that AI systems intend to be used by law enforcement offices in support of law. As referred to in the course, that means in the course of the Article 3 of the directive, they can be used for the detection, investigation, or prosecution of criminal offenses. An example there, it's the NIA system that is used for targeted online radicalization monitoring. It is, there are specific law enforcement exclusions in the high-risk AI. You can see the example. I don't want to waste more time on this. We can move to next, more high level. Next slide, please. Another example in Annex 3 is the administration of just and democratic processes. So high risk, it's called the AI system, intended to be used for influencing the outcome of an election or a referendum or the voting behavior of natural persons. That means that yes, you can use AI for elections purposes, but only if it is legitimate, it is not prohibited, the AI system is not trying to manipulate, and it is called high risk because it can interfere with the voting right. Next slide, please. And when we're discussing about high risk and how important it is for some sectors to be there, we need to know what that means. So this means risk management. This means that there are some mandatory requirements for high risk systems before they can be used on the EU market. So we need risk management, we need data governance and data quality, clean data. We need logging, keep the logs from the operation of the high-risk AI system. We need transparency, and that is really specific, not general transparency. We need human oversight. We need people to be able to see to a level into the AI and stop it from working or start it. We need accuracy in what is inserted and what is the output. Robustness, that means that the system has to stay strong throughout its operation. Cybersecurity, the system has to be strong also when outsiders are trying to penetrate it. Quality management and conformity assessment from a third body to make sure that everything is there and the CE mark is well posed. Then, next slide, please. Of course, we are living in the Gen AI era, so we cannot, the AI Act is also regulating Gen AI models. A few things about this as well. Next slide, please. Thank you. So, this is the disclosure obligations and risk management for the powerful AI models. We are talking about the general purpose AI models. Transparency is the main obligation for all general purpose AI models, together with the risk management for those who have systemic risk. So there is a definition in the AI Act for specific products that give systemic risk. I will give you an example in the next slide. And to that goal, the EU has created a code of practice for transparency of the AI models and for labeling and marking the AI content. So an example of the risk that is addressed by GPA models with systemic risks, it can be called harmful manipulation. So risks from enabling the strategic distortion of human behavior or beliefs. So we need strategic distortion of human behavior or beliefs by targeting large populations of high-stakes decision makers with persuasion, deception, or personalized targeting. There are some more elements to that, but I think you get the idea of what the systemic risk means. And let's move to the next slide, please. So, what are we doing? What is the governance of the EU in relation to the AI? We have the AI office, that's where I'm coming from. And let's go to see the next slide to see the AI office activities. What is the structure? The AI office started to operate in June 2024. It's the Directorate A of the European Commission. So the European Commission has many directorates, has main directorates general. One of them is the Connect. It's the digital, the one related to these AI platforms and other cybersecurity. So Directorate A, it's the one dedicated to the AI office, so to the AI in total. There is a head of the office. There are there is a lead scientific advisor, an advisor for international affairs. We have specific person dedicated to the international affairs in the AI office. And there are 5 different sectors: excellence in AI and robotics. They're working on the robots. AI regulation and compliance, that's where I'm currently working in. AI safety, it's about how to be sure about a few things that are risky in the AI. AI innovation and policy coordination, and AI for societal good. Next slide, please. Recent activities of the AI office, just to keep in mind in case you want to search for more, you want to know more about what we are doing here. We have published a repository of good practices for AI literacy. AI literacy is one obligation in the AI Act. It means that whoever is working with AI has to know what they're doing with AI. So they need to know a few things, they need to be trained. So we have a repository, we have guidelines on the AI system definition and prohibitions, as I said before, with good examples. We have general purpose AI code of practice, how to navigate when the big models are in place, guidelines, and a template for the training data. Of course, there are also webinars online, and the governance is in place. Further to the AI office, we have also the AI board, where the AI office is working with the member states, all member states, in specific sectors. One of them is to appoint member state authorities to enforce the AI Act. And we have the AI Act Service Desk, a very important tool for the companies, for anyone that wants to ask questions specific to on the AI Act. And we reply because we need to help companies navigate. And there are many more upcoming activities. Next slide, please. There are upcoming activities of the AI office. We will update the prohibitions lists. The review will come, and we'll see if there is a need for the prohibitions to be updated. There is guidelines on high-risk classification, how to classify your product as a high risk or not. There are some more important elements. I will not stay more in detail. Next slide, please. As I mentioned before, there is a stakeholders possibility to discuss with the AI office on AI Act problems, and there is a single information platform, so one website for everything related to AI in Europe. And the last slide, please. As you can see, we have also, in terms of AI, we have also deployed and scaled AI factories. So in many countries, 7 in the beginning, 6 more in the afterwards. The AI developments are driven by startups. So the AI factories are trying to provide AI optimized supercomputers. So the countries that have these AI factories set, they have also supercomputers, data centers that are incorporated there and really linked to the supercomputers, and training facilities to use the human capital to make people work together, to use the ecosystems, the university researchers, and make it work for more startups. Today we have 13 AI factories, and thank you. Next slide, please. I'm finished here. Thank you very much.